Hello everyone, welcome back to Law Prep tutorial. In today's video, we'll be discussing one of the most, or if not one of the most important case law pertaining to Indian constitutional history, which is the case of Kesavananda Bharati versus State of Kerala. So this was the most important case, or this is the most important case when it comes to Indian judicial history, because in this case, the doctrine of basic structure was given, or the doctrine of basic structure was propounded, which said that the parliament has the power to amend the constitution, but it cannot amend the constitution in such a way that it altogether alters the basic structure. What is basic structure and how did it come into being? We'll be discussing in this video. So some quick facts regarding Kesavananda Bharati case. So this was the case in which the largest ever bench of Supreme Court was set up in order to deal with the questions regarding the basic structure. So the largest bench was of 13 judges. In no other case such a large bench has been constituted. This was the case in which the largest ever bench, that is of 13 judges, was first set up. Even today, it is the largest bench that was ever formed. The second important point that was held in this case was that it gave the way, or it gave the doctrine of basic structure, which is considered as the most important concept when it comes to Indian judicial system. Okay, and the last, what exactly was given in the, what was exactly did it contain, or what exactly the Kesavananda Bharati decision talked about? It said that Parliament can amend any part of the Constitution. Parliament can amend any part of the Indian Constitution by the virtue of Article 368. Article 368 contains the amendment procedure, or that is taken up for amending the Constitution or parts of the Constitution. But Parliament can amend any part of the Constitution under Article 368, but it cannot amend the same in such a way that it alters altogether the basic structure of the Indian Constitution. So Parliament can amend any part of the Constitution by the virtue of Article 368, but they cannot amend it in a way so as to change the basic structure of the Constitution. So this is one of the most landmark decision, one of the most landmark lines with regards to Indian judicial history. So we'll see how did it all start. How did we travel from Shankari Prasad versus Union of India in the year 1951 till Kesavananda Bharati case in the year 1973. So starting with the first case, that is Shankari Prasad versus Union of India 1958. In this case, it was held that the power of Parliament when it comes to amendment simply means that the Indian Constitution is a living document, which means that the new laws, new provisions can be added into it, and the old provisions which are no longer important or which are no longer needed, they can be removed from it. Say for example, take the example of right to property. Right to property was a part of fundamental rights under Article 19(1)(f) and Article 31. The same has been removed by the 44th Amendment in 1978, and they have been given constitutional status under Article 300A. Okay, so that is done through the process of amendment, and many more provisions, new provisions have been added, which pertaining to municipalities, such as if you have heard of 10th schedule, which deals with disqualification of elected members, that was added by 52nd Amendment in the year 1985. Same way, free and fair education, right to education, that was added by the 86th Amendment. So these all are type of amendments that have been from time to time inserted in the Constitution or removed from the Constitution. Okay, so in Shankari Prasad versus Union of India, it was held that Parliament has unlimited powers when it comes to the amendment. It can amend, it can change, it can amend any part of the Constitution. There is no restriction or there is no limitation on the power of Parliament when it comes to amendment. Okay, this was held in the case of Shankari Prasad versus Union of India. This was the first case law regarding the Parliament's power in order to amend any part of the Constitution. Okay, the next case which came up in front of the courts was Golaknath versus State of Punjab. It was in the year 1967. In this case law, what the courts held was that the power of Parliament the power of parliament when it comes to amending the constitution is not absolute. It is true that parliament can amend any part of constitution, but that is not absolute. There are some parts that the parliament cannot amend, and that part is the fundamental rights. So the court held that parliament can amend anything in the constitution, but cannot amend the fundamental rights. So fundamental rights are included in part 3rd. So which simply meant that in Goloknath case, it was held that the parliament cannot amend the fundamental rights. Bearing the fundamental rights, anything can be amended by the parliament. Okay. So basically what it did was that it gave transcendental status, that is divine status, to the fundamental rights. That parliament cannot even touch the fundamental rights. It gave transcendental status to the fundamental rights, which means that the fundamental rights are divine, they are basic rights, and parliament cannot change them in any way. This was held in the case of Goloknath versus State of Punjab in the year 1967. So in order to overrule this, the parliament came up with the 24th Amendment. The parliament came up with 24th Amendment in the year 1971. In this amendment, what did parliament say was that it was parliament who came up with 24th Amendment in the year 1971. And in this amendment, what did parliament say was that parliament has absolute right to amend any part of the constitution, including the fundamental rights. So parliament could amend any part of the constitution, including the fundamental rights, and there was no restriction whatsoever when it comes to the amendment power of the parliament. This was in the case. This was in the 24th Amendment that was brought up in the year 1971. So what it basically do was that it overruled whatever was held in Goloknath versus State of Punjab. So in the case of Goloknath versus State of Punjab, the fundamental rights were given transcendental status, which means they were given divine status. But the same by the parliament in the 24th Amendment, they were their transcendental status was removed, and they were given ordinary status, which means that the parliament could by amendment remove or add to fundamental rights. This was held in the case of 24th Amendment 1971. Now comes the most important case, that is Kesavananda Bharati case. So before we deal with what was held in the Kesavananda Bharati case, we will first deal with the facts pertaining to Kesavananda Bharati case in the year 1973. So who was Kesavananda Bharati? There might be a question as to who was Kesavananda Bharati. So Kesavananda Bharati was a chief priest of Adnir Mutt in Kasaragod in Kerala. So he was a chief priest. He was the chief priest of Adnir Mutt. There was a mutt known as Adnir Mutt in the city of Kasaragod in Kerala. Kasaragod में जो है, Kasaragod एक city जो है वो जो कि केरला में है, उसमें Adnir Mutt है. Adnir Mutt के जो chief priest थे वो थे Kesavananda Bharati. So he owned a land. He owned some land, and the Mutt as well, the Adnir Mutt as well owned some land. So there was some law passed by the Kerala government. There was some law passed by the Kerala government, which was Land Reforms Amendment Act in 1969. Land Reforms Amendment Act of 1969. And through this act, the Kerala government wanted to acquire some property of the Mutt, the Adnir Mutt. So Kesavananda Bharati challenged the same. He moved to Supreme Court under Article 32. We have read about Article 32. Article 32 deals with violation of fundamental rights. And in case there is a violation of fundamental rights, you can directly move to Supreme Court and have a rectification of the same. So if there are any violation of fundamental rights that have been mentioned in the part 3rd, you can directly go to, or you can directly approach the Supreme Court under Article 32 in the form of various writs such as habeas corpus, mandamus, certiorari, quo warranto, and so on and so forth. You can also approach the High Court, but that is under Article 226, and you have to file a writ petition for the same. The difference between Article 32 and 226 is that Article 32 is a mandatory provision, which means that if there is a violation of fundamental rights, the Supreme Court cannot revoke or cannot refuse to hear a petition, because Article 32 in itself is a fundamental rights. That fundamental right. That is why B.R. Ambedkar, the father of our Indian Constitution, held that Article 32 is the heart and soul of the Indian Constitution, whereas Article 226 is not a mandatory provision. Okay, that is the basic difference between Article 32 and Article 226. So Kesavananda Bharati accordingly went or moved to Supreme Court under Article 32. And what did he say was that this land reform, this act, the Kerala Land Reforms Act 1969, is violating his fundamental rights. And which all fundamental rights were being violated according to him? The first one was Article 25. Article 25 talks about freedom to practice and propagate religion. Second is Article 26, that is freedom to manage religious affairs. Everybody has some fundamental rights to manage his or own religious affairs. Article 14, which talks about right to equality. Article 19(1)(f), which has been omitted by 44th Amendment. And Article 31, which talks about compulsory acquisition property, that is also removed by 1978. 44th Amendment, 1978. But how did he? So there must be a question as to how he could claim violation of Article 19(1)(f) and Article 31 when there are no more fundamental rights. So you must remember that this was held in the case. This case was filed in the year 1973, and these two rights, the last two rights, have been removed in the year 1978. Okay, so there were 5 grounds, or there are 5 fundamental rights under which Kesavananda Bharati alleged that his fundamental rights have been violated. So this law must be struck down. That is Land Reforms Amendment Act in 1969. So this was a basic or brief overview of the case. And what was held in this case law we'll be dealing with. The petitioner challenged those amendments which the parliament had brought in order to nullify the effects of Golaknath case, that is 24th Amendment and 25th Amendment. So accordingly, he was saying, Kesavananda Bharati was saying that, first of all, his 5 fundamental rights, that is Article 25, Article 26, Article 14, Article 19(1)(f) and Article 31 are being violated by Kerala government through this act. Secondly, Kesavananda Bharati, the petitioner who filed the petition, challenged that the 24th Amendment passed by the Parliament in the year 1971. The 24th Amendment, as we have discussed, dealt with the powers of Parliament, which said that the Parliament has power to amend any part of the Constitution. So Kesavananda Bharati, the petitioner, challenged this amendment and said this, that the power to amend any part of the Constitution is not absolute. Okay, so what exactly was held in this case? केशवानंद भारती ने कहा कि मेरे 5 फंडामेंटल राइट्स वायलेट हो रहे, साथ ही साथ आई एम चैलेंजिंग 24th अमेंडमेंट दैट वाज पास्ड बाय पार्लियामेंट इन द ईयर 1971. 24th अमेंडमेंट कहता था कि पार्लियामेंट के पास पूरी पावर है कि पूरे कॉन्स्टिट्यूशन में कुछ भी चेंज कर सकते हैं, कुछ भी अमेंड कर सकते हैं. ओके, तो इस केस में केशवानंद भारती केस में केशवानंद भारती ने जो है इस चीज को भी चैलेंज किया, 24th अमेंडमेंट को भी चैलेंज किया. तो 5 तो फंडामेंटल राइट्स हो गई और एक हो गया 24th अमेंडमेंट, इनको जो है चैलेंज किया. फिर इस केस में जो है बोला क्या गया, इस केस में हेल्ड किया गया बाय द 13th बेंच ऑफ द इंडियन सुप्रीम कोर्ट. उन्होंने ये हेल्ड किया कि देयर इज नो डाउट पार्लियामेंट हैज अनलिमिटेड पावर व्हेन इट कम्स टू अमेंडिंग द कॉन्स्टिट्यूशन. पार्लियामेंट हैज अनलिमिटेड पावर. पार्लियामेंट हैज अनलिमिटेड पावर, and under the exercise of that unlimited power, Parliament can change anything in the Constitution. Parliament can amend anything in the Constitution, which in other words simply meant that Supreme Court said that 24th Amendment that was brought by the Parliament in 1971, that is completely valid. But what it also held was that Parliament can amend anything in the Constitution, that is true, but it cannot amend the Constitution in such a manner. ऐसे आप कॉन्स्टिट्यूशन को अमेंड नहीं कर सकते कि उसका जो है बेसिक स्ट्रक्चर ही जो है वो पूरा चेंज हो जाए. आप अमेंड करो, पार्लियामेंट के पास पावर है कि आप कॉन्स्टिट्यूशन के कोई भी पार्ट को अमेंड करो, लेकिन आप अमेंड ऐसे नहीं कर सकते कि उसका पूरा का पूरा बेसिक स्ट्रक्चर जो है वो चेंज हो जाए. सो दिस वाज हेल्ड इन दिस केस. अब बेसिक स्ट्रक्चर में आता क्या है? तो बेसिक स्ट्रक्चर, द लिस्ट ऑफ बेसिक स्ट्रक्चर इज नॉट एग्जॉस्टिव, विच सिंपली मीन्स दैट यू कैनॉट हैव all the things which will come under basic structure. That will be decided by the courts on case to case basis. But there is a brief list which tells us about what all come under the basic structure and what all don't come under the basic structure. So supremacy of constitution is a basic structure. If parliament makes any law which violates supremacy of constitution, then by applying the doctrine of basic structure, the same law will be declared to be void or invalid. Second is rule of law. Rule of law simply means that no one is above the law. Everyone is equal in the eyes of law. So if parliament makes any law which violates the provision of rule of law, then the same law will be declared invalid on the grounds of that it violates the doctrine of, or it violates the basic structure. Third is independence of judiciary. So if parliament makes any law which violates the independence of judiciary, then the same law will be declared invalid because it is violative of basic structure. Doctrine of separation of power. Separation of power simply means that there are three organs of the governance. They are judiciary, they are executive, and they are the legislature. So if there is any law which dilutes separation of power, then that law will also be declared as invalid or void because it infringes upon the basic structure. Next is sovereign democratic republic. Sixth one is parliamentary form of democracy. And then comes principle of free and fair elections. So if parliament makes any law which violates these provisions, then the same law will be declared void by the courts simply because it violates the basic structure. Now this list is not exhaustive. It simply means that these are not the only ones which can violate the basic structure. There are many others as well, such as federalism, secularism. These all come under the category of basic structure. So parliament cannot make laws which violate the basic structure. So the basic structure doctrine simply means that, in simple words, if I were to conclude, it simply means that parliament has unlimited power to amend the constitution, but it cannot amend the constitution in such a way that it violates the basic structure of the constitution. Basic structure is simply which is important and which cannot be violated at any cost. So this was the Kesavananda Bharati case which we discussed today, starting from Shankari Prasad versus Union of India. Then we dealt with Golaknath versus State of Punjab, that was held in the year 1967. Then the parliament came up with 24th Amendment 1971, and lastly we dealt with the most important case law of Indian judicial history, that is Kesavananda Bharati case, Kesavananda Bharati or State of Kerala case. So this was all about this case. So thank you everyone, and we will meet in another video. Thank you everyone.